And now we see it once again. We see it where the judge, and I told her, Justice Peterson, Gilbert Peterson wife, I said, my lady, what you doing? I don't know you. But a case come up that is political. You is politics. Your husband is politics. You and your husband is rowley friend and neighbor and thing for decades. Come out, let somebody else do that. Didn't I say that? And now, Sunday Express, Gilbert Peterson's wife, Justice Betsy Ann Lambert Peterson, all of a sudden, before the case is heard about whether there's apparent bias and whether she should recuse herself and whether there's conflict of interest, she takes the unprecedented step of making a statement as a judge. And she says, I have no political connection. That's debatable. That's what will be discussed. You have a husband, 45 years. Y'all have been friends with Rowley, 45 years. Y'all are neighbors with Rowley. Gilbert Peterson is Rowley's lawyer. Y'all lime, barbecue, cook curry, corn soup together, Inez Gate. Y'all are partners in the Inez Gate property because when you own a property, you put in a share in the community group and so on. So you're kind of business partners also, plus your husband. Let's read what the judge says. So said High Court Judge Betsy Ann Lambert Peterson, who on Friday took the unprecedented step of issuing a personal statement defending herself against a claim of bias. My marriage has not dimmed my ability to exercise a high degree of agency in my personal and professional life. Yes, my lady, that may be absolutely true. But does that matter when it comes to apparent bias? We're not talking about actual bias, and that could be debated. But when determining apparent bias, your professional integrity and your ability to dissociate yourself from your loving husband and your friendship with Rowley and his wife and so on, that does not arise, my lady, and you know that. So why are you writing that nonsense in a statement? Her formal personal statement was issued last Friday, moments before the hearing of the application of bias. Don't you think your statement, formal statement made public, is inappropriate before a hearing is to be heard? Something is to be heard before another judge? Wouldn't that, if someone was to do that in a case that you were to hear and give opinion, you know that's totally inappropriate. What is causing you to do all of this, my lady? In a statement, Justice Lambert Peterson, and this is the critical part, I want you all listening. Justice Lambert Peterson confirmed that her husband, Gilbert Peterson SC, is one of the Prime Minister's golfing friends. She confirmed that he has purchased 2 townhouses in Tobago from Inez Investment, the same development in which the Prime Minister purchased a townhouse. She confirmed that he is the chairman of 2 state companies for which he receives stipends, appointed by Keith Rowley, the Prime Minister, and the Cabinet. She confirmed that he spoke in favor of Attorney General Reginald Armour in the motion of no confidence which was considered by the Law Association last year. Confirmed that he is a director of RH Gas, which received a bunkering license, a lucrative multi-million-dollar US license from the Ministry of Energy. And she confirmed that her husband has represented Keith Rowley in several court matters. However, Justice Lambert Peterson has maintained that she can adjudicate objectively on the TTRA case, which is before her, and which the political and financial stakes are high for the Rowley government as it seeks to implement a critical pillar in the tax-raising policy. The matter not only has financial implications, but political ramifications, since the opposition has criticized the legislation, describing it as a violation and an assault on the Constitution. Lambert Peterson said the matter involving the legal challenge to the TTRA was docketed to her through an administration process over which I have no control. This matter, like any other constitutional motion listed before me, will be determined on its merits. Yes, madam, you had no control over how it got docketed to you. But you did have control over recusing yourself based on the list of confirmation that you've made about the close, intertwined, intimate relationship that your husband and yourself have with Keith Rowley and his family and his wife as neighbors and business partners, and receiving your husband, of which you live with, and the two will become one. So money coming into the home from state companies and state board and state contracts and bunkering contracts, all of these things come and help your life, and they influence you. Plus you love your husband dearly. You've married him for how many years? So let me remind you, Madam Justice. Let's see the law, the case law on apparent bias. And what is apparent bias? The case law really got settled finally, Porter versus McGill in 2002, by the House of Lords unanimously. So it have no home and away like Lymouth like to say. Previously, the basis of apparent bias was a reasonable suspicion of bias, right? That was decided in UK Limited versus Bayfield Property, where there was a real danger of bias was the benchmark, or a possibility of bias. They changed in that it was 1999, and Lord Bigham gave his judgment where he said, if for any other reason there were real grounds for doubting the ability of the judge to ignore extraneous considerations, prejudices, and predilections, recusal would be necessary. The judge must consider all the objectives made, and if there are any grounds for doubt about the possibility of bias, he must exclude himself. So that was what it was before. My lady, you in breach of all the old benchmark for apparent bias that says the reasonable person, but then the newer one, the way it says the informed reasonable person, because a reasonable person who has no clue about nothing might just say, well, but the informed person, like we on Douglar Politics, we are informed that you are Gilbert Peterson's wife. We are informed that Gilbert Peterson is Rowley's good friend for decades. We are informed that you and Gilbert Peterson and Rowley and his wife are neighbors in Gate and work together in that community. That you and Gilbert Peterson as husband and wife have had intimate relationships with and many family functions with Rowley. That Gilbert Peterson, your husband, is Rowley's attorney in many matters, personal lawyer. And that Gilbert Peterson is the beneficiary of bunkering contracts and state board appointments based on Rowley. And Gilbert Peterson receives many millions of dollars in briefs to advise Rowley's government. We know this because we are informed. We are the reasonable, informed person. In the case medicaments and related goods, 2001, number 2 of 2001, WRR 700, Lord Phillips MR said, we changed from the old test, which was RV Goff, to Lord Hope's exposition in Porter versus McGill, that a fair-minded and informed observer, and the threshold is a real possibility rather than the danger of bias. So now the threshold moved to it being a real possibility. Is it a real possibility that all that love, all that intimacy, all that connection in a political case, that there's a real possibility that you could be biased by one side or the X? And then when we read now, it was codified. So you went to McGill, Porter versus McGill, and then you also have the International Union, the European Union, the court, the conduct, the code, civil procedure. This was written in the Civil Procedure Review of the European Court, Judicial Code of Conduct, March 2013. The 6 core principles known as the Bangalore Principles of Judicial Conduct. I do all this for you, Justice Betsy. I thought I would just say, kill God, that your brethren, that your friend and thing. Come out of that now. I thought that would have done it, but it didn't. You come out with a statement, so now I have to go in detail to tell you how you're wrong. So the 6 core principles known as the Bangalore Principles of Judicial Conduct. 1, judicial independence is a prerequisite and a fundamental guarantee of a fair trial. Number 2, impartiality is essential. Not a deputy essential like Gadsby Dolly, you know. Impartiality is essential. Integrity is essential. Why are you fighting so hard to hear the case? You have colleagues who don't have no bunkering contract, who don't have no husband who does line with Rowley, who don't have no husband who does play golf with Rowley, who don't have no husband who does represent Rowley in case, who don't have no husband who buy place to be neighbor in Inez Gate with Rowley, who don't have no husband who get millions of dollars and brief from Rowley, who don't have no husband who on 2 state boards get appointed by Rowley, who don't have no husband who love Rowley. Why is this so hard for you to understand, my lady? Propriety and the appearance of propriety. Number 5, equality of treatment. Number 6, competence and diligence. The guide goes on to state, judicial independence is sometimes mistakenly perceived as a privilege enjoyed by judges, whereas it is in fact the cornerstone of our system of government in a democratic society and a safeguard of the freedom and rights of the citizen under the rule of law. It confirms all the precautions that were present before that the judge had to take to recuse himself or herself if bias could be discerned by the reasonable man. In Lesage versus Mauritius Commercial Bank, Lord Kerr stated, inter alia, whether in the mind of the informed observer, the failure to consider the propriety of their continuing to hear the case creates a possibility of bias, is to be judged both prospectively and retrospectively. The actual conduct of the judges during the trial is to be examined, therefore to see whether it supports or detracts from the suggestion that there was the appearance of possible prejudice. My lady, how you adjudicated the matter? In favor of Rowley, not so? So he didn't detract. You see, if you had ruled in favor of the other side, then it would have detracted from the breaches of the tenets of apparent bias. But it didn't. In this case, retrospectively, it added to the pain that you must be feeling for your inappropriate decision making. The CCJ that you and the PNM and everybody love, they mirrored the exact statement and agreement of the guide of the European Council. So, in summing up, the case of apparent bias does not require actual bias, on you stating that you can be professional and you can differentiate between your love for your husband and friendship with Rowley and you can adjudicate the case. That's not the issue. The benchmark is for apparent bias. As long as an informed, reasonable individual believes, based on the interacting relationships that have existed or exist, that there will be bias on one side. End of story. And you cannot deny that. If you admit all of that connection and then you want to deny it,